would be potentially disastrous. For you to block out topics that arise simply because they were not part of your game plan in conducting the interview, or are not on your checklist. As with so many areas of the law, you may not know what you are looking for until you find it. In interviewing a client about incorporating a business, for example, you may stumble across a lead from something the client says that could involve fraud or criminal prosecution on a matter unrelated to the incorporation. Don't block this out. Pursue what appears to be reasonably related to the law office's relationship with the client. Check with your supervisor. Again, let common sense be your guide. Flexibility is one of the foundations of common sense. Section F. What does the client want? A number of points can be made about many clients, particularly new ones. They are not sure what they want. They change their minds about what they want. They are not aware of their legal and non-legal options. The legal problem they tell you about involves other legal problems that they are not aware of and that even you may not be aware of at the outset. Suppose a client walks into the office and says, "I want a divorce." The following observations might be possible about the client. 1. The client has an incorrect understanding of what a divorce is. 2. The client says she wants a divorce because she thinks this is the only legal remedy available to solve her problem. 3. If the client knew that other options existed, e.g. annulment, judicial separation, a restraining order, a support order, she would consider them. 4. What really troubles the client is that her husband beats the kids. A divorce is the only way she thinks she can stop it. 5. The client does not want a divorce. She is being pressured by her husband to institute divorce proceedings. He threatened her with violence if she refuses. 6. The client consciously or unconsciously wants and needs an opportunity to tell someone how badly the world is treating her, and if given this opportunity, she may not want to terminate the marriage. 7. If the client knew more about marriage or family counseling, she would consider using it before taking the drastic step of going to a law office for a divorce. If any of these observations is correct, think of how damaging it would be for someone in the law office to take out the standard divorce forms and quickly fill them out immediately after the client says, "I want a divorce." This response would not be appropriate without first probing beneath the statement to determine what in fact is on the client's mind. Some clients who speak only of divorces and separation agreements are receptive to and even anxious for reconciliation. The danger exists that the client might be steered in the direction of a divorce because no other options are presented to her, because no one takes the time to help her express the ideas, intentions and desires that are lurking beneath the seemingly clear statement, "I want a divorce." This is not to say that you must psychoanalyze every chant or that you must always distrust what the chant tells you initially. It is rather a recognition of the fact that most people are confused about the law and make requests based on misinformation about what courses of action are available to solve problems. Common sense tells us to avoid taking all statements at face value. People under emotional distress need to be treated with sensitivity. We should not expect them to be able to express their intentions with clarity all the time in view of the emotions involved and the sometimes complicated nature of the law. Assignment 8.1. During an interview, the client makes the following statements. What areas do you think need to be probed to make sure the office does not misunderstand what the client wants? I want to institutionalize my sick father. B. I want my boss arrested for assaulting me. C. I want to file for bankruptcy and go out of business. Section G. Assessing your own biases. You need to be aware of how your personal feelings might affect your work on the case. Such feelings are the foundation of bias, which is an inclination or tendency to think, and bias an inclination or to act in a certain way. How would you answer the following question? Am I objective tendency to think and to act enough that I can assist a person even though I have a personal distaste for what that in a certain way? A danger of son wants to do or what that person has done. Many of us would quickly answer yes prejudgment to this question. We all like to feel that we are level-headed and not susceptible to letting our prejudices interfere with the job we are asked to accomplish. Most of us, however, have difficulty ignoring our personal likes and dislikes. Assignment 8.2. In the following fact situations, to what extent might an individual be hampered in delivering legal services because of personal reactions toward the client? Identify potential bias. A Mr. Smith, the client of your office, is being used by his estranged wife for custody of their 2 small children. Mr. and Mrs. Smith live separately, but Mr. Smith has had custody of the children during most of their lives while Mrs. Smith has been in the hospital. Mrs. Smith has charged that Mr. Smith often yells at the children, leaves them with neighbors and daycare centers for most of the day, and is an alcoholic. Your investigation reveals that Mrs. Smith will probably be able to prove all these allegations in court. B. Mrs. Jones is being sued by Mr. Jones for divorce on the ground of adultery. Mrs. Jones is the client of your office. Thus far, your investigation has revealed that there is considerable doubt over whether Mrs. Jones did in fact commit adultery. During a recent conversation with Mrs. Jones, however, she tells you that she is a prostitute. C. Jane Anderson is seeking an abortion. She is not married. The father of the child wants to prevent her from having the abortion. Jane comes to your office for legal help. She wants to know what her rights are. You belong to a church that believes abortion is murder. You are assigned to work on the case. D. Paul and Victor are a gay couple who want to adopt Sammy, a 6-month-old baby whose parents recently died in an automobile accident. Sammy's maternal grandmother is not able to adopt him because of her age and health. She opposes the adoption by Paul and Victor because of their lifestyle. Your office represents Paul and Victor. You agree with the grandmother's position, but have been assigned to work on the case. Tom Donaldson is a client of your office. His former wife claims that he has failed to pay court-ordered alimony payments, and that the payments should be increased substantially because of her needs and his recently improved financial status. Your job is to help Tom collect a large volume of records concerning his past alimony payments and his present financial worth. You are the only person in the office who is available to do this record gathering. It is clear, however, that Tom does not like you. On a number of occasions, he has indirectly questioned your ability. P.EDIITHK skills of a paralegal: objectivity, the state of being dispassionate, the absence of a bias. Having analyzed the fact situations in assignment 8.2, do you still feel the same about your assessment of your own objectivity? Clearly, we cannot simply wish our personal feelings away, or pretend that they do not exist. Nor are there any absolute rules or techniques that apply to every situation you will be asked to handle. Nor are the following admonitions very helpful. Be objective, be dispassionate, don't get personally involved, control your feelings. Such admonitions are too general, and when viewed in the abstract, they may appear not to be needed, since we want to believe that we are always objective, detached, and in control. We must recognize that there are facts and circumstances that arouse our emotions and tempt us to impose our own value judgments. Perhaps if we know where we are vulnerable, we will be in a better position to prevent our reactions from interfering with our work. It is not desirable for you to be totally dispassionate and removed. A paralegal who is cold and feeling and incapable of empathy is not much better than a paralegal who self-righteously scolds a client. It is clearly not improper for a paralegal to express sympathy, surprise, and perhaps even shock at what unfolds from the client's life story. If these feelings are genuine, and if they would be normal reactions to the situation at a given moment, then they should be expressed. The problem is how to draw the line between expressing these feelings and reacting so judgmentally that you interfere with your ability to communicate with the client now and in the future. Again, there are no absolute guidelines. As you gain experience in the art of dealing with people, you will develop styles and techniques that will enable you to avoid going over that line. The starting point in this development is to recognize how easy it is to go over the line. Some paralegals apply what is called the stomach test. If your gut tells you that your personal feelings about the case are so intense that you may not be able to do a quality job for the client, you need to take action. Talk with your supervisor. You may have some misunderstandings about the case that your supervisor can clear up. You may be able to limit your role in the case or be reassigned to other cases. Without breaching client confidentiality, contact your local paralegal association to try to talk with other paralegals who have handled similar situations. They may be able to give you some guidance. Attorneys often take unpopular cases involving clients who have said or done things that run the gamut from being politically incorrect to being socially reprehensible. As professionals, attorneys are committed to the principle that everyone is entitled to representation. Paralegals need to have this same commitment, but attorneys and paralegals are human beings. No one can treat every case identically. In the final analysis, you need to ask yourself whether your bias is so strong that it might interfere with your ability to give the needs of the client 100% of your energy and skill. If such interference is likely, you have an obligation not to work on the case. As we saw in Chapter 5, the failure to recognize the presence of this kind of bias can have ethical implications. It is unethical for you to be working on a case to which you cannot devote 100% of your professional skills. There should not be a conflict of interest between your personal feelings or belief system and the client's need for vigorous representation from every member of the legal team. Assignment 8.3 Think about your past and present contacts with people who have irritated you the most. Make a specific list of what bothered you about these people. Suppose that you are working in a law office where a client did one of the things on your list. Could you handle such a case? Our Section H Communication Skills Introduction. You have probably been interviewed hundreds of times in your life. You may also have interviewed others frequently. The next assignment and the class exercise that follows it are designed to identify what you now know about interviewing in general. Assignment 8.4 Write down your answers to the following questions. When you have finished this chapter, come back to what you have written and ask yourself whether your perspective has changed. A. List some of the times you have interviewed someone. List some of the times you have been interviewed by someone. B. Describe what you feel are the central ingredients of a good interview in any setting. C. Describe a bad interview. From your experience, what are some of the worst mistakes an interviewer can make? D. Describe what you think are some of your strong and weak points as an interviewer. What can you do to improve? The following exercise involves an interview role played in class. After watching this interview, you will be asked to deduce some principles of communication for interviewing. Class Exercise 8.b. In this exercise, 2 students will role play a legal interview in front of the class. The rest of the class will observe the interview and comment on it. Instructions to client. You will role play the part of a client. A month ago you sprained your back while lifting a computer and carrying it from one room to another. You are an accountant. When you came to work that day, you found the computer on your desk. It did not belong there, and you did not know how it got there. You decided to move it to another desk. That was when you sprained your back. You have come to the law office for legal advice. You have already seen an attorney in this office who has agreed to take your case. An interviewer has been assigned to conduct an interview with you to obtain a complete picture of what happened. This interview will now be role-played in front of the class. The basic facts involve the accountant and the computer. You can make up all other facts to answer the interviewer's questions. Make up the name of the company for which you work, the details surrounding the accident, etc. You can create any set of facts as long as your answers are reasonably consistent with the basic facts given to you above. Instructions to interviewer. You will play the role of the interviewer in the case involving the sprained back. You are a paralegal in the office. All you know about the case thus far is that the office has agreed to represent the client, and you have been assigned to interview the client for detailed information about the client and about the accident. Start off by introducing yourself and stating the purpose of the interview. Then proceed to the questions. Take notes on the client's answers. You do not need to know any law in order to conduct the interview. Let common sense be your guide. Your goal is to compile a comprehensive picture of the facts as this client is able to convey them. Consult the material on fact particularization (FP) as you prepare and formulate questions. Be sure to listen carefully to the answers, so that you can ask appropriate questions that seek more details on the facts contained in the answers. The class will observe you in order to assess the manner and content of the interview. A good deal of constructive criticism may develop from the class discussion. As you listen to the criticism, try to be as objective as you can. It is difficult to conduct a comprehensive interview, and probably impossible to conduct one flawlessly. For every question that you ask, there may be 20 observations on how you could have asked it differently. Hence, try not to take the comments personally. Instructions to class. You will be watching the interview involving the sprained back. You have two tasks. 1. Read through the LICS Legal Interviewing Communications Score form. Then close your book, so that you will give your complete attention to the interview. After the interview, fill out the LICS form. The teacher will ask you to state the total score you gave the interview, or to submit this score to someone who will calculate the average score from all students' scores. Identify as many do's and don'ts of interviewing as you can. If you were writing a law office manual on how to interview, what would you include? What guidance would you give an interviewer on taking notes during the interview, asking follow-up questions, maintaining eye contact with the client, etc.? After you observe the interview, discuss specific suggestions on what an interviewer should or should not do. Ideas will also come to mind while you are filling out the LICS form. Legal Interviewing Communications Score LICS. How to score. You will be observing the role-playing of a legal interview and evaluating the interviewer on a 100-point scale. These 100 points will be earned in the 4 categories listed below. The score is not based on scientific data. It is a rough approximation of someone's oral communication skills in a legal interview. A score can be interpreted as follows: 90 to 100 points, outstanding interviewer 80 to 89 points, good interviewer 60 to 79 points, fair interviewer 0 to 59 points. A lot more work needs to be done. Of course, the LICS does not assess the interviewer's ability to write an intake memorandum of law for the file. See Exhibit 8.3 and the discussion of the intake memo at the beginning of this chapter. Category I. Role identification on a scale of 0 to 5. How well did the interviewer explain his or her role and the purpose of the interview? A 5 score means the interviewer took time to explain clearly what his or her job was in the office, and what he or she hoped to accomplish in the interview. A low score means the interviewer gave little or no explanation at all, or mumbled an explanation without being sensitive to whether the client understood. Category I score. Category 11. Factual detail on a scale of 0 to 80. How would you score the interviewer's performance in asking enough questions to obtain factual comprehensiveness? How well was FP performed? An 80 score means the interviewer was extremely sensitive to detail in his or her questions. A low score means that the interviewer stayed with the surface facts, with little or no probing for the who, what, where, how, and why details. The more facts you think the interviewer did not obtain, the lower the score should be. Category II score. II category III. Control on a scale of 0 to 10. How would you score the interviewer's performance in controlling the interview and in giving it direction? A 1 score means the interviewer demonstrated an excellent sense of control and direction. A low score means the interviewer rambled from question to question, or let the client ramble from topic to topic. Category III score. II category IV. Earning the confidence of the client on a scale of 0 to 5. How would you score the interviewer's performance in gaining the trust of the client and in setting him or her at ease? A 5 score means the interviewer appeared to do an excellent job of gaining the trust and confidence of the client. A low score means the client seemed to be suspicious of the interviewer and probably doubted his or her professional competence. The more the interviewer made the client feel that he or she was genuinely concerned about the client, the higher the score. The more the client obtained the impression that the interviewer was just doing a job, the lower the score. Category IV score. I1 total score. Analysis of a legal interview introduction. We will now examine portions of a hypothetical interview involving Sam Donnelly, who walks into the law office of Day seeking legal assistance. Last month he was a passenger in a car that collided with a truck. Our goal in this analysis is to identify guidelines that can help you conduct competent interviews. In particular, we want to increase your sensitivity to the large variety of factors that affect the quality of the communication between a client and an interviewer. Earlier in the chapter, we discussed fact particularization as an important technique in achieving factual comprehensiveness in the interview. Here our focus will be the broader context of interviewing and communication. Assume that Mr. Donnelly is in the office of William Fenton, one of the partners of Day. During their meeting, the law firm agrees to represent Mr. Donnelly. The arrangement is confirmed in the retainer that Mr. Donnelly signs. See Exhibit 8.1 for a sample retainer. At the conclusion of the meeting, Mr. Fenton calls his paralegal, Jane Collins. He asks her to come to his office so that he can introduce her to Mr. Donnelly. Attorney. As the paralegal walks into Mr. Fenton's office, he says Mr. Donnelly, I want to introduce you to Jane Collins, who will be working with me throughout the case. I have asked her to schedule an appointment with you to do a comprehensive interview that will cover the facts you and I began to discuss today. Jane will be an additional contact for you throughout the case. If at any time you can't reach me, let Jane know what concerns, questions, or needs you have. I will be reviewing all of Jane's work and will be meeting with her regularly. Jane is a trained paralegal. She is not an attorney and therefore can't give legal advice, but she can do many things to help me represent you. Client. Nice to meet you. Paralegal. Jane walks over to where Mr. Donnelly is sitting and with a smile extends her hand to offer a firm handshake. I'm very pleased to meet you, Mr. Donnelly. I look forward to working with you on the case. Let me give you one of my cards so that you'll know how to reach me. Client. Thank you. Attorney. I've already explained to Mr. Donnelly that you will be doing an in-depth interview with him on the case. Paralegal. Yes. When would be a good time for me to call you to set up an appointment for the interview, Mr. Donnelly? It is extremely important to note that the supervising attorney, Mr. Fenton, has taken the initiative to introduce the client to the paralegal. This sets the tone for the client-paralegal relationship. Many clients have little more than a general understanding of what a paralegal is. Here, the introduction by the supervising attorney is very specific in identifying Jane as a non-attorney who has been trained to help attorneys represent clients. She will also act as a liaison between the attorney and the client. Note also the manner in which the paralegal treats the client. She walks toward the client to greet him with a firm handshake and a smile. She tells the client that she looks forward to working with him. She gives him her business card. This is often appreciated because the client is probably meeting several new faces during the first few visits to the law office. She is very deferential to the client in asking when she can call him for an appointment. These are signs of a paralegal who is willing to go out of her way to make the client feel important. Throughout the remainder of the chapter, we will examine additional techniques paralegals can use to set clients at ease. Preparing for the interview. How do you get ready for an interview? Exhibit 8.6 lists some of the major steps you should take to prepare. The list assumes that this is one of the first legal interviews you have conducted. In addition to the suggestions in Exhibit 8.6, try to observe someone interview a client. FMD, out if anyone else in the office will be conducting an interview soon. If so, ask permission to sit in. Watching others interview can be very instructive. Another way to pre-hypothetical, not actual or real but presented for purposes of discussion or analysis. Pair is to read some intake memos or other reports written after interviews. In other cases, they can be found in the open or closed files of other clients. Pay particular attention to the amount and kind of information obtained in those cases. Your mental attitude in preparing for the interview is very important. You need to approach each interview as if it is going to be a totally new experience for you. It is very dangerous for you to think that you know what the client is going to say, no matter how many times you have worked on a particular kind of case before. The danger is that you will not be listening carefully to what the client is saying. An interviewer who has an "I've heard it all before" attitude may block out what is unique about the facts of this client's case. The hallmark of the professional is to view every client, every problem, and every incident as different and potentially unique. There's never been one like this before. A professional interviewer, therefore, keeps probing for more facts to try to show that this case is not like all the rest. The goal of the professional is to find out what makes this case stand out. The trademark of the bureaucrat, on the other hand, is to see the similarities in clients' problems and incidents. These cases are a dime a dozen. The bureaucrat clusters things together into coherent groupings and patterns so that time can be saved and efficiency achieved. The bureaucrat feels that chaos could result if we viewed everything as potentially unique. An interviewer who has a bureaucratic attitude usually does not spend much time probing for facts. His or her goal is to fit this case into a category of similar cases handled in the past. We all have within us professional and bureaucratic tendencies that are sometimes at war with each other. Our bureaucratic self is very practical. Our professional self can be a bit extreme in its search for uniqueness. When conducting legal interviews, however, or engaging in any task in the representation of a client, our goal is to try within reason to let our professional selves dominate. Preparing for an interview. Schedule the interview during a time when you will not be rushed or constantly interrupted. Schedule the interview at a location that will be private and convenient for the client. Find out from your supervisor if the client has any special needs, such as wheelchair accessibility. Call or write the client in advance to confirm the date and place of the interview. Give an estimate of how long the interview will take. If the directions are complex, offer to send or fax a map hand-drawn if necessary. Remind the client of anything you want him or her to bring to the interview, e.g. insurance policies, copies of tax returns. Anticipate and prepare for the client's comfort, e.g. a comfortable chair, a pad and pencil in case the client wants to take notes, a supply of tissues. Also know where you can quickly obtain fresh water or coffee after offering them to the client early in the interview. If the office has already opened a file on the client, read everything in it before the interview. Bring any documents in the file that you may want to question the client about or have the client review during the interview. Have a final brief meeting with your supervisor to make sure you understand the goals of the interview. Find out if the office has any checklists you should use in asking questions. If none exist, prepare an outline of about a dozen major questions you will ask the client. You will have many more questions in the interview, but you can use this outline as a guide. Spend a little time in the law library doing some general background research in the area of the law involved in the client's case to obtain an overview of some of the major terminology and legal issues. This overview may suggest additional questions you will want to ask during the interview. Prepare any forms you may want to ask the client to sign during the interview, e.g. consent to release medical information, authorization to obtain employment history records. Have your own supplies ready for note-taking. Some interviewers recommend using different colored pens so that you can switch colors when the client is telling you something you want to give particular emphasis in your notes. Walk into the interview with the attitude that the client will be telling you a story that you have never heard before. Do not assume you know what the client is going to say, even if you have handled many cases of this environment. You need to consider the impact of the physical setting or environment in which you conduct the interview. It will usually take place in the office of the interviewer. If this office is not private enough, however, try to reserve the conference room or borrow an available office from someone else if it would be more private than your own. In our example, let us assume that Jane Quinn's office is suitable for her interview with Sam Donnelly. There is a knock at Jane Quinn's door. She gets up from her chair, goes over to the door, opens it, and says, as she extends her hand, "Paralegal. Hello, Mr. Donnelly. I'm Jane Collins, Mr. Fenton's paralegal. It's good to see you again. Won't you come in? Did you have any trouble finding the office? Client. No, I had to use the bus, but it worked out fine. Paralegal. Let me take your coat for you. Please have a seat. Left bracket. The paralegal points the client toward a chair on the opposite side of the desk from where she sits. They face each other. Right bracket. Note the seating arrangement the paralegal selects as illustrated in diagram A. I stands for interviewer and C stands for client. Diagram A. A number of other seating arrangements could have been used. Diagram B. Diagram C. The chairs can be arranged so that the interviewer and the client sit on opposite sides of a desk. Diagram A. Diagonally across a desk. Diagram B. On the same side of a desk. Diagram C. Or in another part of the room, away from the desk altogether. Diagram D. Seating arrangements are usually made at the convenience of the owner of the office. Rarely is enough thought given to how a particular arrangement may help or hurt the flow of communication. Sometimes the seating arrangement will create an austere and official atmosphere. Other settings may be close and warm. Of the 4 seating arrangements diagrammed above, which do you think would be most effective? Which would you feel most comfortable with? Which do you think the client would be most comfortable with? A number of factors can help you answer these questions. First, there is probably no single seating arrangement that will be perfect for all situations. The interviewer must be flexible enough to experiment with different arrangements. For most legal interviews, you will be taking extensive notes as the client answers your questions. If you are going to make any notes about the client that you may not want him or her to see, e.g. appears reluctant to answer, you will want to select a seating arrangement that does not allow the client to read what you are writing. To some extent, seating arrangements can be a reflection of your personality. How do you want to project yourself as an authoritative figure? If so, you might be inclined toward the seating arrangement in diagram A. Do you, on the other hand, want the client to feel closer to you and not to have the impression that you are hiding behind a desk? Do you think it would ever be wise to change a seating arrangement in the middle of an interview? If a particular arrangement is used for the initial interview, do you think a different diagram D arrangement might ever lie appropriate for follow-up interviews with the same client? When clients look up, do you want them to be looking straight at you diagram A, or do you think that it might be more comfortable for them to be able to face in other directions diagram B, without appearing to scatter their attention? Of course, an office is much more than an arrangement of desks and chairs. Describe the potential benefits or disadvantages of the following. Numerous posters on the wall display political slogans, e.g., "Down with the Republicans," or "Pro-choice is pro-family." A copy of the latest issue of the Rush Limbaugh newsletter is on the desk. The desk is cluttered with papers, books, and half-eaten food. A sign on the wall says, "Don't even think of smoking here." You want the office to help you project a professional image of yourself. A messy desk usually suggests the opposite. Be careful about explicit messages around the room. Your political views may clash with those of the client. Do not broadcast your politics by having partisan literature on the walls or the desk. What do you think of the "no smoking" sign? Courtesy would suggest a more friendly way of letting clients know that they should not smoke in your room, e.g. a sign that says "Thank you for not smoking." Getting started. Note that the paralegal, Jane Collins, went to the door to greet the client. Suppose that instead, she had remained in her chair and called "Come in a loud voice. Do you think it makes any difference whether the interviewer walks over to the client? When you walk into a room with someone, you are communicating the message "Come share my room with me." If, however, you are seated at your desk and call the visitor in, the message to the visitor is likely to be, "This is my room. I control it. You have my permission to enter." Although this is not necessarily an inappropriate message, it is not as friendly and warm as going to the door to escort the client in. Notice, however, that the paralegal apparently did not go out to the front entrance of the law firm to greet the client. Here is what may have happened. The client came to the front door, was greeted by a receptionist, was told to wait in the reception area, and was then given directions to find the paralegal's office on his own. If this is what happened, it was a mistake. The paralegal should have left instructions with the receptionist to call her when the client arrived, and the paralegal then should have gone out to the reception area to greet the client and personally walk him back to her office. This would be the most courteous approach. Furthermore, you do not want clients roaming around offices even if they know the way. A wandering client may overhear confidential conversations between other members of the firm, or see open files of other clients on the desks of secretaries. It can be unethical for the law firm to allow outsiders to know anything about the cases of other clients. This danger is minimized if the paralegal escorts the client from the front door to her office. Note that the paralegal reintroduced herself to the client. "Hello, Mr. Donnelly. I'm Jane Collins, Mr. Fenton's paralegal. It's good to see you again." She does not expect the client to remember who she is. It is a sign of courtesy to reintroduce yourself at the beginning of a second meeting. And never call a client by his or her first name, unless expressly invited to do so by the client. Paralegal: "Thank you for coming in today, Mr. Donnelly. Are you ready for today's session?" Client: "Ready as I can be." Paralegal: "Good. How have you been?" Client: "Not bad, considering all this mess. I can't believe all this is happening." Paralegal: "Being involved in an accident can be very upsetting. It must be very hard for you. Our office has handled cases like this before. While no one can predict how a case will turn out, you can rest assured that we will be doing everything possible to help lessen the burden on you." Client: "Thank you." Paralegal: "Let me ask you, Mr. Donnelly, is there anything that you want to cover now before?" Client: "This letter came in the mail this morning. It looks like the truck company has its lawyers on the case." Paralegal: left bracket She takes the letter from Mr. Donnelly and spends a few moments reading it. Right bracket This is a letter from the attorney representing the truck company, seeking information from you. They obviously don't know yet that we represent you. Once they knew you are represented, it is improper for them to contact you directly. They need to go through your attorney. I'll let Mr. Fenton know about this letter right away. Why don't I photocopy it before you leave so that you can keep a copy for your records? After Mr. Fenton sees this, we'll let you know if there is anything you need to do about the letter. For now, let us take care of it. Early on, the paralegal thanked the client. "Thank you for coming in today." Throughout the case, the office may ask the client to do many things such as come to meetings, sign documents, and collect information. Each time, you should express appreciation for doing what was asked. Never expect the client to thank you, although this may occur. You do not want the client to have the impression that you are doing the client a favor. The reverse is always true. Hence, constantly be appreciative. Soon after inviting the client in, the paralegal asked, "Did you have any trouble finding the office?" And a little later, "How have you been?" It is a good idea to begin the interview at a personal level, with some small talk about the weather, how the client is doing, or a recent sports event the client might know something about. This helps put the client at ease. The client may still be a bit nervous about the accident or whatever led to the conflict and the involvement of attorneys. Being a little light-hearted and personal for a few moments at the beginning of the interview may help break the ice. When clients are particularly stressed or overwhelmed, you need to provide reassurance that the office will be actively working on the case and that the situation is manageable. The paralegal did that here when she told the client the office has handled similar cases in the past and would be doing everything possible to help lessen the burden on him. Comments such as these should help reassure the client. Of course, many clients want to be told they are going to win their cases. Avoid making any statement that could be interpreted as a promise or guarantee of success. Otherwise, the office could be sued for breach of contract if the case is not successful. Instead of telling a client you've got a great case, say something like the following: "There is no way of telling how a case will turn out. You've got a lot of good points in your favor, and we're going to work as hard as we can for you." The paralegal also told the client being involved in an accident can be very upsetting. It must be very hard for you. Here, the paralegal is expressing understanding and empathy for the client's predicament. This is extremely important. The comment tells the client that the paralegal is listening to what the client is saying. Mr. Donnelly refers to the mess he is in and says, "I can't believe all this is happening." Rather than ignoring this comment, the paralegal lets the client know that she has heard what he said. This is comforting for clients. On the other hand, you don't want to be patronizing or condescending. A comment such as "you poor fellow" would obviously fall into this category. Interviewers often learn a large number of highly personal facts about the client's life. Think of how you would feel if you were revealing such facts about yourself to a stranger. Think of how you would want this person to react to what you are revealing. At such a vulnerable time, clients need understanding and compassion. This does not mean that you should lose your objectivity. As indicated earlier, if it would be natural for you to express an emotion in response to what a client tells you, express the emotion. For example, "I'm very sorry to hear that," or "I can understand why you'd be angry." At the same time, you need to have an appropriate professional distance from the emotions and drama of the client's story. Of course, never be judgmental of the client. Do not ask the client, "Why did you do that?" If your tone is one of suspicion or disbelief, clients should not feel that they are required to justify their actions or inactions to you. This obviously would not encourage open communication between interviewer and client. Also important was the paralegal's question left bracket is there anything that you want to cover now, before we begin? Early in the interview, find out if the client has any immediate concerns or questions on his mind. This should be done not only as a matter of breach of contract, a cause of action, in which a party seeks a court remedy for the alleged failure of a party to perform the terms of an enforceable contract. Courtesy, but also as a technique to make sure the client has your undivided attention. On the way into the law office, the client may have been thinking of several things he wants to ask about. He may be worried that he will forget them, or he may be a little embarrassed about asking his questions. Give the client a chance to express anything on his mind at the outset before you begin your barrage of questions. In our example, this technique worked. Mr. Donnelly did have something on his mind, the letter he received from opposing counsel. Paralegal. Our goal today is to obtain a comprehensive statement of the facts of the accident. It will take at least an hour, maybe a little more. As Mr. Fenton told you, I'm not an attorney. I'll be able to help on the case in many ways, but I won't be able to give you legal advice. That will have to come from Mr. Fenton. If anything comes up today that calls for legal advice, I'll bring it to Mr. Fenton's attention so that we can get you the response you need. Since I work for an attorney, you should know that everything you tell me is protected by the attorney-client privilege. Client. Fine. Paralegal. Before we begin, Mr. Donnelly, you mentioned that you had to take the bus in. Is there a problem with your car? It wasn't involved in the accident with the truck, was it? Client. No. I let my brother borrow my car today. Paralegal. All right. I want to start by getting an overview of what happened on the day of the accident. Then we'll go back and fill in the details. I'll be taking detailed notes to make sure that I remember everything you say. Okay, what happened that day? This is the second meeting between the paralegal and Mr. Donnelly. Although the supervising attorney, Mr. Fenton, told Mr. Donnelly that Jane Collins was not an attorney, it is a good idea for the paralegal to reinforce this point herself. Paralegals, who have a lot of contact with clients, are often pressured by clients to give legal advice. Making it clear at the outset that this is inappropriate can cut down on this pressure, although unfortunately, it will not eliminate it. The paralegal also told the client that what he tells her is protected by the attorney-client privilege. The client needs to know this, but not in this way. The phrase attorney jargon, technical language. Client privilege is legal jargon. It is technical language that does not have an everyday words that do not have a meaning. Avoid jargon unless the client needs to know it and you explain it in language everyday meaning the client can understand. When you use jargon or confusing terms, do not interpret the client's lack of questions to mean that the client understands the jargon. Do not wait for the client to ask you to explain unfamiliar terms. Take the initiative to provide explanations. In our example, it probably would have been sufficient to tell Mr. Donnelly that what he tells her will be confidential rather than using the more technical phrase, attorney-client privilege. Another useful technique for beginning an interview is to briefly state the major goal of the interview here, to obtain a comprehensive statement of the facts of the accident. Give the client an overview of what you hope to accomplish and how long it may take. Let the client know you will be taking notes, so you will have an accurate record of what he says during the interview. As indicated earlier, the document that contains the detailed report of the interviewer is sometimes called the intake memo. See Exhibit 8.3. Authors in the office working on the case need to be able to read and rely on this report, since they all cannot interview the client. Occasionally, your supervisor will want you to tape record the interview. Be sure the client consents to the recording. At the beginning of the interview, say, "This is Jane Collins, a paralegal in the law office of Day &Day. Today's date is March 13th, 2002. 1 am in our law office with Mr. Samuel Donnelly. Mr. Donnelly, have you agreed to have this interview tape recorded?" The latter question and answer will help disprove any allegations that you secretly recorded the interview. A good interviewer is always listening for clues to other legal or relevant non-legal problems. There is always a danger that an interviewer will block out anything that does not fit within the topics scheduled for discussion. In our example, the paralegal said to Mr. Donnelly, (YOU mentioned that you had to take the bus in. Is there a problem with your car? While the car apparently has nothing to do with the case, it was worth inquiring into. Suppose, for example, the client is not driving because of injury to his eyes caused by an eye doctor. Or perhaps the client has had a contract dispute with an auto mechanic. It is a good idea to listen for suggestions or clues to other problems provided by a client. If you do not want to cover the matter immediately, make a note to raise it later in the interview at a more appropriate or convenient time. The major techniques and guidelines for beginning an interview are summarized in Exhibit 8.7. Kinds of questions. 1 of the early questions the paralegal asked the client was (WHAT happened that day. This is known as an open-ended question. It is a broad, relatively unstructured question that rarely can be answered in 1 or 2 words. An open-ended question gives the client more control over the kind and amount of information to be provided in response. It also gives the interviewer an opportunity to size up the ability of the client to organize his or her thoughts in order to present a coherent response. Here are some other examples of open-ended questions. What brings you in today? What led to the crisis at the bank? One of the most frequently used categories of open-ended questions is the overview question, which asks for a summary of something, such as an important event. For example, what happened during your first year in college? Or Jane Quinn's question, (WHAT, open-ended question, a broad and structured question that rarely can be answered in 1 or 2 words. Overview question, a question that asks for a summary of an event or condition. Exhibits. Beginning the interview, introduce yourself by name and title. If this is your second meeting with the client, reintroduce yourself. Do not call a client by his or her first name unless invited to do so by the client. Express appreciation each time the client does something the office asks, e.g., come in for an interview, read and sign a document. Make sure the client understands that you are not an attorney and cannot give legal advice. Start at a personal level, e.g., with some small talk, rather than launching right into the task at hand. Review the goals of the interview with the client based on the assignment from your supervisor, and provide an estimate of how long the interview might take. Make the client feel that his or her case is special. Avoid giving the impression that you are engaged in anything boring or routine. Never tell a client how busy you are. It suggests to the client that he is bothering you, and might give the impression that the office is disorganized. Express understanding and empathy for the client's predicament without being condescending. Do not be judgmental. Make sure the client understands that what he or she tells you is confidential. Find out if there are immediate concerns that the client wants to raise. Avoid legal jargon unless the client needs to become familiar with the jargon, and you provide clear definitions and explanations. Let the client know you will be taking notes and why. Listen for clues to other legal and relevant non-legal problems that the office may need to explore. Begin new topics with open-ended questions. See Exhibit 8.8 on the kinds of questions an interviewer can ask. Spend the first few minutes obtaining an overview/outline of the entire event or transaction. Then go back to obtain the details. Encourage the client to give you the facts chronologically as a story, with a beginning, middle, and end. If more than one event is involved in the case, cover them separately in the same chronological way. Then go into how the events are interconnected. If the client appears overwhelmed or unusually distressed, try to provide reassurance by letting him or her know that the office is actively working on the case and is doing everything it can. Do not, however, promise results or say anything that a client could interpret as a promise, or even as a prediction of what the outcome of the case. I.ntii till. Smuesoya pakalual closed-ended question. A narrowly structured question that usually can be answered in one or two words, also called a directed question. Chronological question. A question designed to encourage the interviewee to tell the story of what happened chronologically step by step. Leading question. A question that suggests an answer within the question. Corroborative question. A question designed to verify or corroborate facts by seeking information beyond what is provided by the interviewee. Combination question. A question that has more than one part. Multiple choice question. A question that asks the interviewee to choose among two or more options stated in the question. Add-on question. A question that stacks one or more additional questions within it. Happened chat day. An open-ended request, e.g., tell me about the problem, invites the same kind of broad response but is phrased as a request rather than as a question. Open-ended questions or requests invite the person questioned to give a long and potentially rambling answer. Hence they should not be overused. These questions are of 10 most effective when beginning a new topic in the interview. At the opposite extreme is the closed-ended question, which is a narrowly structured question that usually can be answered in one or two words. Examples: how old are you? What time did the accident occur? Did you receive the letter? Closed-ended questions give the interviewer more control over the interview because they let the client know precisely what information is sought. If the facts of a case are relatively complex, you should consider spending the first few minutes asking overview questions in order to obtain an outline of the entire event or transaction, and then going back to obtain the details. Once you have the big picture, you will be better able to see connections among the individual facts. The paralegal in our example took this approach when she said, "I want to start by getting an overview of what happened on the day of the accident. Then we'll go back and fill in the details." She followed this up with the open-ended overview question, (WHAT happened that day. Both the request for an overview and the detailed questioning should be designed to encourage the client to sell the events of the case chronologically. The case may have many confusing aspects. The client may be inclined to talk about 4 or 5 things simultaneously: accident, the hospitalization, the events leading up to the accident, the deceitfulness of the other side, etc. The best way to conduct an orderly interview is to help the client structure a case as a story with a beginning, middle, and end. Hence you should regularly ask chronological questions such as what happened next, or what did you do then. If a client says something substantially out of chronological sequence, politely say, "Could we get to that in a moment? First I want you to finish telling me what happened after ... Although you want to see the interconnections among the various events of the case, the discussion may become tangled and confusing unless you cover one topic at a time in the same methodical manner. In most instances, the most methodical way is chronologically. In general, you should avoid asking leading questions, in which a answer is suggested in the question. For example, you didn't return the call, did you? You've forgotten everything that occurred during the meeting. The danger of a leading question is that a nervous client or witness will simply give you the answer you appear to want. Leading questions might sometimes be useful when trying to challenge something that a hostile witness is saying, but this should not be the case with your own client. If a client is having difficulty remembering something, e.g., the weather, on a particular day, a leading question might help jog the memory, e.g., was it raining that day? If a client needs constant prodding through leading questions, however, you may have reason to doubt the client's entire story. Another category is the corroborative question, which seeks to verify or corroborate facts beyond the word of the client or witness. For example, were there any passengers in the car who will back that up? In general, you should avoid combination questions, those with more than one pair. They can confuse the person being interviewed. There are two kinds of combination questions: multiple choice and add-on. A multiple choice question asks the client or witness to choose among options presented by the interviewer. It is an or question. For example, did you personally review the balance sheet, or did you rely exclusively on what the accountant told the committee? The interviewee may not remember both options and simply respond to the last part of the question. An add-on question is simply several questions phrased as one. It is an and question. For example, when did you arrive in Boston, and how long did you stay there? What was your salary when you began work at the company at the time of the accident and on the date you were terminated? Avoid add-on questions. For the same reason, you should avoid most multiple choice questions. They can be confusing. There are some combination questions that are relatively simple. For example, was he driving a car or a truck? What is your husband's name, and where was he born? Yet the danger of confusion still exists, and the better practice is to break all combination questions into individual questions that are asked separately. See Exhibit 8.8 for an overview of the major kinds of questions an interviewer can ask. Attentive listening studies have shown that clients rate evidence of concern as being more significant than the results they obtain from a law office. This is a remarkable conclusion. Of course, clients want to win their cases. Yet they are also desperate for a sympathetic ear. Being involved in a legal dispute is often traumatic for them. In addition to being treated competently as a plaintiff or defendant, clients want a law office that is genuinely concerned about them as persons. One of the best ways to demonstrate concern is through attentive listening. This simply means that you take affirmative steps to let the client know that you have heard what he or she has said, and that you consider every meeting with the client important. Exhibit 8.9 summarizes some of the major techniques of attentive listening. Experienced paralegals often handle the same kind of case over and over. Clients, however, want to feel that their case deserves and will get individual attention. They do not want their cases handled in an assembly line or mass production manner. While they like having experienced attorneys and paralegals working for them, they are particularly pleased when they feel that the office is treating their case as special. Comprehensiveness. A major goal of most legal INTER/IEWS is to achieve factual comprehensiveness. You want to obtain as many relevant facts as the client is able to give. The most important technique in accomplishing this goal is fact particularization, discussed earlier in the chapter. See Exhibits 8.4 and 8.5. Also important are corroborative questions that ask about documents, attentive listening, taking affirmative, ongoing steps to let an interviewee know that you have heard what he or she has said, and that you consider the meeting with him or her to be important. Exhibit 8.8 Kinds of questions. Here are some of the major categories of questions, some of which overlap. Open-ended questions. Those that are broad and relatively unstructured, allowing the client or witness to express what is on his or her mind. They rarely can be answered by one or two words. Examples: what can we do for you today? Tell me what happened on the day of the accident. What kind of a marriage did you have? Closed-ended questions. Those that narrowly focus the attention of the client or witness and call for a very brief answer, often yes or no. Examples: are you seeking a divorce? Were you wearing your glasses when you saw the accident? Did your husband ever hit you? Overview questions. Those that seek a summary of a major event or condition. Examples: would you first give me a general picture of what happened? What are the major incidents that led to the dismissal? Could you start me off by giving a brief description of what happened at the party before the shooting? Chronological questions. those designed to get the client or witness to tell the story of what happened chronologically step by step. Examples: then what happened? What did he say after he saw the accident? What happened next? Leading questions. Those in which the answer is suggested in the question. Examples: where was the fender dented? The car wasn't damaged when you received it, was it? You were traveling 75 mph. Corroborative question. Those designed to verify or corroborate facts by seeking information beyond the word of the client or witness. Examples: who else saw the accident? Were you the only one who complained? Do you have receipts? Combination questions. Those that contain more than one part. Examples: did you accept the offer, reject it, or ask for more time to respond? Multiple choice: what school does your child attend and are you satisfied with how well he is doing there? Add-on. Attentive listening: make it obvious to the client that he or she has your full attention. If you know that there might be an interruption during the interview, alert the client and apologize in advance. Occasionally lean forward toward the client as he or she speaks. Avoid being fidgety or appearing nervous. Take notes. This is an obvious sign that you think what the client is saying is important. Maintain eye contact whenever you are not taking notes. As the client speaks, give frequent _yes nods. Also say or I see when the client momentarily pauses while answering your questions. This will let the client know you are following what he or she is saying. Periodically let the client know he or she is providing useful information. Make comments such as "that could be very important" or "I'm glad you recall the event in such detail." In addition to listening to the words of the client, listen to the feelings the client is expressing through gestures and other body language. Words are not the only way a client lets you know that he or she is anxious, suspicious, worried, or in pain. At appropriate times, restate a feeling the client is trying to describe, e.g., the stress you were under must have been overwhelming. You may want to do this in the form of a question, e.g., you were really angry when you found out, weren't you? Occasionally read something from your notes out loud to the client and ask if you have correctly recorded what he or she has said. At other times, paraphrase what the client says in your own words to encourage the client to provide further clarification or to confirm that you have understood what the client has said. Let me see if I understand what you've said. This reinforces the value of precision in the practice of law, as well as letting the client know how important this interview is. Ask spontaneous questions that occur to you while listening to an answer of the client. This helps demonstrate that you are not trying to fit the client's answers into your preconceived notions about the case. Rather, you are following the client's train of thought. Refer back to what the client said earlier, e.g., when we were discussing the purchase, you said that your father wanted his brother to manage the property. Could you tell me what you meant? Never express impatience, no matter how frustrated you are at the client's failure to answer what you feel is an easy question. While a client is answering a question, try to avoid interrupting unless he or she is rambling and you need clarification before the client moves to another point. Do not finish the client's sentences for him or her, no matter how certain you are of what the client is trying to say. Finishing someone's sentences demonstrates your impatience and is condescending. I or other individuals who can support the version of the facts the client is relating. See Exhibit 8.8. Most clients want to tell you about the facts that support their case. You need to encourage them to tell you negative as well as positive facts. Tell them how important it is for the attorney to know all the facts. The attorney for the other side may find out about negative facts. Indeed, one of the preoccupations of the other side is to find the facts that will hurt the client. The client's attorney must know all the facts in advance so that he or she can prepare a response when these facts come out. Clients are often opinionated. Probe beneath the opinions to obtain the underlying facts. If a client says he's a liar or the road is dangerous, probe beneath these opinions to get at the underlying facts that led the client to reach these opinions. Again, fact particularization will help you uncover them. Earlier we said that checklists of questions can be helpful in preparing for an interview. Be careful in using checklists, however. Although they can provide guidance on what to cover in the interview, you must be flexible enough to deviate from the checklist when relevant topics come up that are not on the checklist. Use any checklist, whether written by others or prepared on your own, as no more than a starting point. Suppose, for example, you are interviewing a client about her financial assets. You are working from a checklist of questions on wages, real estate holdings, stocks, bonds, etc. During the interview, the client happens to mention an ailing grandparent who is very fond of the client. This suggests the possibility of another possible asset, inheritance from this grandparent. Suppose, however, the checklist contains no questions about future inheritances. Common sense, one of the guides to formulating questions discussed earlier in the chapter, should tell you to ask whether the client thinks she might be a beneficiary in someone's will. Take accurate notes on the facts the client gives you. Recall that one of the components of fact particularization is to record the extent of the certainty/uncertainty a client expresses about a fact. Suppose the client tells you, "I'm not sure how fast an approaching car was going," but then says it was about 50 mph. Your final report, based on your notes, should say, "When I asked the client how fast the other car was going, he said he was not sure. Then he made it about so mph." This lets the supervising attorney know that the client may be vulnerable as a witness in court if questioned about the matter of speed. An interviewer does not achieve the desired factual comprehensiveness unless he or she asks about and records the extent to which the client is certain or uncertain about the facts conveyed. The techniques for obtaining factual comprehensiveness are summarized in Exhibit 8.10, Ethical Concerns Paralegal. Left bracket, telephone rings, right bracket. "Excuse me, Mr. Donnelly." "Yes, hello. How are you?" "No, the Jackson case has been resolved. Mr. Jackson decided not to go through with his suit after McDonald's made its offer." "You're welcome." "Sorry, Mr. Donnelly, let's get back to the... A legal interview must be conducted competently and ethically. Unfortunately, there are more than a few opportunities for an interviewer to run afoul of ethical rules." Mr. Donnelly has just heard the paralegal discuss the Jackson case on the phone. This is a violation of the paralegal's ethical obligation to preserve the confidence of a client. Even though Mr. Donnelly may not have understood anything about the Jackson and McDonald case, he was not entitled to hear what he heard. He should not even know that Jackson or McDonald is a client of Day. Revealing information about a client is a breach of confidentiality, whether it is done intentionally or carelessly. Mr. Donnelly may now have the impression that the paralegal will be as careless about discussing his case in front of strangers. Client: "A friend of mine told me that if another car rams into you and commits a clear traffic violation, their negligence is automatic. Is that true?" Paralegal: "I'll take that question up with Mr. Fenton and get back to you. All legal questions like that need to be dealt with by an attorney." Another major ethical danger that can arise during an interview is giving legal advice. As we saw in chapters 4 and 5, legal advice consists of applying laws or legal principles to the facts of a particular client's case. The more contact a paralegal has with clients, the greater the likelihood the paralegal will be asked to give legal advice. This is especially true during legal interviews. Clients are often hungry for answers. Mr. Donnelly is no exception. He asked the paralegal whether a traffic violation makes one's negligence automatic. Even general questions about the law could be interpreted as questions that call for legal advice. Mr. Donnelly is probably trying to understand how the courts will handle his case. Achieving factual comprehensiveness, apply the technique of fact particularization to all the major facts the client tells you and that you need to cover. See Exhibits 8.4 and 8.5. Ask corroborative questions. See Exhibit 8.8. Encourage the client to tell you about negative facts. Probe beneath client opinions to obtain the underlying facts. Follow available checklists of questions, but be prepared to ask questions not on the checklist if they pertain to relevant topics that come up during the interview. Ask questions to determine the extent to which the client is certain or uncertain about an important fact. Suppose paralegal knows the correct answer. Think of how tempting it would be for her to answer the question. It takes a lot of willpower for her to refrain from answering. She wants to appear intelligent. We all want to show off what we know. Be conservative, however, about ethics. See Exhibit 5.1 in Chapter 5. When in doubt, avoid giving an answer. The paralegal told Mr. Donnelly that she would get back to him after consulting with Mr. Fenton. This is better than coldly saying, "I'm not allowed to answer that question." When she said all legal questions like that need to be dealt with by an attorney, she is also helping to train the client about the limitations inherent in the paralegal's role. This may cut down on pressures in the future from Mr. Donnelly's attempts to ask her for legal advice. Some of the major areas of ethical concern are summarized in Exhibit 8.11. Ending the interview. The interview is over when you have accomplished the objectives of the interview, or when the client is not able to provide you with any additional information. The client may need to check some of his records at home or contact a family member or business associate in order to answer some of your questions. Although much of the missing data can be communicated on the phone or through the mail, do not be reluctant to reschedule the interview if needed. Give the client the opportunity to raise anything that he thinks should have been covered. For example, you could say, "Before we end today's session, let me ask you if there is anything you think we haven't covered, or haven't covered enough." If the client raises anything, you may want to take some additional time now to go over the client's areas of concern, or you may have to tell the client that you'll get back to him on when you will be able to go over those concerns. The important point is to find out how the client feels about what was discussed during the interview, and to respond to any of his concerns. Often the client needs to sign documents that authorize the office to obtain confidential information about the client, e.g. a consent to release medical information. Be sure to explain the document clearly to the client and give him some time to read through what he is being asked to sign. Do not simply hand the client a document and say, "I'll need your signature on this form that will allow us to get your medical records." Here is a more appropriate approach. Paralegal. Left bracket, handing the document to him, right bracket. "Mr. Donnelly, I want you to take a look at this document. It's a consent to release medical information. We'll use it to ask doctors, hospitals, or other medical providers to give us information about your medical condition. Would you please take a moment to read it and let me know if you have any questions about it? If not, there's a space at end of the document for your signature." Client. "Okay, paralegal. Once you sign it, I'll keep the original and give you a copy for your records." Avoiding ethical problems during interviews. Exhibits 11. If you cannot avoid phone interruptions or visits by others to your office during the interview, be sure that you do not discuss the facts of other clients' cases. Never mention the names of clients or their opponents in front of another client, even if you are certain that the latter will not recognize these names. Excuse yourself and leave the room if you must discuss anything about other cases. While talking to the client, do not have open files of other clients on the desk. Do not let the client wander in the corridors of the office, e.g., to go to the coffee pot. You do not want the client to overhear conversations about other cases among attorneys, paralegals, secretaries, or other employees. Make sure the client understands you are not an attorney. Resist pressures from the client to give legal advice. When in doubt about whether a question you are asked calls for legal advice, do not answer. Refer the matter to your supervising attorney. If the client says anything during the interview that suggests the possibility of a conflict of interest, e.g., the client tells you that the opposing side's spouse once was represented by your law firm, stop the interview and check with your supervisor about whether you should continue. Never discuss fees with the client. The client will want to know what is going to happen next after the interview. Remind the client of any scheduled appointments, such as doctor visits or depositions.